Everybody knows that if you make a threat against somebody else, you might just get yourself into trouble. But what if you make a legal threat against somebody that you really shouldn't have been making in the first place? We call those unjustified threats. What many people don't know is that if you make an unjustified legal threat against another person, you yourself, the maker of the unjustified legal threat, might find yourself in a whole heap of legal trouble yourself, with the person aggrieved or the company aggrieved being able to claim damages against you for losses sustained, obtaining an injunction against you to refrain you from making further unjustified threats, and a declaration that it was in fact an unjustified threat. What I'm talking about is unjustified threats of trademark infringement. In a nutshell, this means you're threatening someone else with infringing upon your trademark when they're not. This is exactly what happened in this case, where this chap, literally chap on a bicyclette, as his YouTube channel is called. In fact, let's go over there and subscribe now so you can get more of this content later on. Subscribe to me as well while you're at it. Now, it goes without saying that all of this video is for educational purposes only. It is not legal advice to any of the parties involved, but it is a guidance to anyone that might find themselves in the same situation. And it's done with all good intentions so that everybody can understand the law a little bit better and hopefully keep themselves out of trouble. So this chap, literally chap on a bike, uploads videos of his journeys on a bike routinely, presumably to document his journeys, save footage in case he gets injured so he can refer to it later, and heaven forfend anybody were to commit a road traffic offence, that he can report this then to the police, all of which is perfectly legal, of course, because if you're recording it for any one of those purposes, it's all perfectly fine. This is out in a public place, it's not fixed surveillance, and so on, but we digress. So that's exactly what happened in this case, only he captured not only in the video itself the name of a company on the side of one of these Luton tail lift van things, which is more akin to a lorry, but then he also labeled the video so that he could find it later, and it's identifying what happened in the video. So let's take a quick look at the video, let's take a look at the threat that came along, and let's take a look at the law so we can all understand exactly what's going on here. So there are a couple of comments I'll make about the video as we go along. You can see on the left-hand side, there is another cyclist up on the left. There is a cycle lane, but it's interspersed with these different areas where you can't ride in it. So presumably that's why he's riding on the outer edge of this cycle lane here. So he's riding literally on the edge of the line. Now, this is the close, quote-unquote, close pass here. Now, just to be clear, there is no defined close pass offence in law. What it is when another vehicle is driving without due care for other road users and consideration for other road users, and if they were to collide and it's very close and so on, it could amount to careless driving or even dangerous driving. So in my view, right off the bat, not that we're talking about this in this video, but in my view, this is a close pass because I even feel like I could reach out and touch the wing mirror of this Ford Luton van driving past here. So the problem comes as you can just about make out the logo on this first door of the van here, that as it goes past a little bit further, quite clearly close pass, you can quite clearly see the name of the company on the side of the van with the phone number, the website, and so on, which is why it's then been labelled up as to what the vehicle was and where it was and the name of the company. This company is obviously upset about it, the fact that it's on YouTube. Presumably, they feel that it's going to damage their reputation. People might leave bad reviews and so on, all of which they shouldn't do because obviously doing that is not going to be genuine because they won't be a genuine customer unless, of course, they are a genuine customer, but they probably not. So let's first of all take a quick look at the law. When somebody has a trademark registered, they are conferred with certain rights. And essentially, they have the exclusive rights in the trademark to market their products and services and indeed their company. And so if any other company were to use a registered trademark to market their goods and services, they would be infringing this trademark, and thus the proprietor of the registered mark would have a cause of action. However, the key part of all of that is infringing use is when you are using someone else's trademark to market goods or services. This is the first part of the test for trademark infringement. Indeed, this is set out very neatly in the very next section of the Trademarks Act, Section 10, which defines what infringement is. It says a person infringes a registered trademark if he uses in the course of trade a sign which is identical to the mark in relation to the goods or services which are identical with those for which it's registered. And then there are, of course, variations of infringement. So there's an identical sign with identical goods, an identical sign with similar goods, or a similar sign even with identical goods, and so on. The point is, it must be used in the course of business to market goods or services. So how then does that relate to this situation here? Well, unless chap on a bike is somehow marketing goods or services using this company's name, then he's not going to be infringing the trademark per the definition in the Trademarks Act, because if he's not marketing goods or services, he can't be infringing the mark. So now we move to the email threat and why that might land the company in more trouble than they had first anticipated. So without reading this email in its entirety, there are bits of it here that explain that the company is the owner of a registered trademark. And whilst they're quite correct to say that the YouTube video does incorporate the trademark in video titles and descriptions and so on, they do say that it's improperly used, which is not really the case, because he's not, insofar as I can see, marketing any goods or services. So I don't agree with that. They go on, moreover, the trademark is represented in a modified URL format. This seems to be a strategy to evade detection by search algorithms. I don't really agree with that either. It's potentially an accusation of dishonesty, which I don't think is very well founded. But I can understand why they might be upset that their van is now splattered across YouTube with what many people will consider to be bad driving. They then reference a Google search and various videos that pop up in response to that search, but then go on to say this unauthorized use is confusing our customers, negatively impacting our brand reputation, and potentially harming our sales and the exclusivity of our trademark. Now, buried within that statement is, I think, with respect, the real reason. The real reason being, in my view, is that it's quite likely to negatively impact the brand reputation, given that some people feel very strongly about drivers driving too close to cyclists in a manner that they feel dangerous. But is it unauthorized use? In my view, no, unless he's marketing goods or services. It's not unauthorized use. Is it confusing to customers? Well, let's think this through. Somebody might be genuinely searching for this company and land on this video. Are they likely to be confused that this video is in some way directly connected with this company? I very much doubt it, because the video quite clearly shows exactly what's happening. It's a cyclist riding along and the van drives by. Is it potentially harming sales and exclusivity of the trademark? I doubt it, but it's possible. But in any event, it still doesn't amount to trademark infringement. Then, of course, it goes on to a request to immediately stop using the trademark, refrain from using it, and then references a solicitor's website to embolden the threat. It's unclear at this stage as to whether there's any link between this company and this firm of solicitors at all. At the moment, I would probably doubt it. Again, it says we require promptly removing the company's name from the video and so on. But here's where we get to the real problem. If you remember what I said about the unjustified threats at the beginning of this video, if somebody makes an unjustified threat of trademark infringement, then that in itself might give rise to a cause of action. Now, the bit that I would be concerned about if I were advising any company in this kind of situation that has made these kind of threats like this, it's this bit here. It says, we aim to resolve this issue amicably, but are prepared to take legal action if necessary. Furthermore, we'd like to clarify that our marketing activities, including advertisements on various platforms, vans, buses, do not imply our responsibility for incidents involving those mediums. Well, no, to be fair, it's the driver, although it does reflect badly on the brand, and there could be an argument as to vicarious liability, i.e. the company being liable for the actions of its drivers. Although in most instances, it would be the driver that would be found liable, but there's not much they can do about the damage to the reputation. But it is what it is. If you put the name of your company on the side of your van and your driver drives badly, your company might suffer a loss to its reputation. That's just the way the world works. We believe you've attempted to damage our reputation by misleading the public in your videos. Then we'd be in the realms of defamation. So if what they are really saying is, we think that you are damaging our reputation, then one defense to that might be, well, it's the truth. And any person that is in possession of any facts at the time and has had the opportunity to see the full video, which you have, because I'll link it in the description below, then if the meaning of what they're complaining about is that the driver is bad and anyone watching it could come to the same view, then the defense of the truth, or at the very least opinion, could come into play. Although if we go back to the video for a moment and look at what's in the description here, it says the road markings aren't the best as they force cyclists out into the middle of the road. That's the explanation I gave you at the beginning, but that's no excuse to perform a dangerous overtaking maneuver and nearly knock someone off their bike. It's slow-moving traffic. The driver got nowhere, has stopped at red lights for a few moments later. References the company with a question mark as if to call them out to say, I don't think I'll be bothering with any fancy plasterwork from yourselves. Wouldn't want a road death on my conscience if one happened whilst you were out driving, which seems entirely plausible. That, to me, is quite clearly opinion. It's just what this video maker thought about this incident at the time and has provided the full video so that anybody can get their own view of it. But back to the email and what I'm concerned about. So this goes on even further. It then goes on with another request to formally and request the immediate removal of the company's name from the videos. So they've requested that, I think, 3 times now. But then again, the bit that I would be concerned about where it says non-compliance will lead us to seek legal redress and claim any related expenses, including lost sales. Now, of course, the last bit there makes clear what they are really worried about. They are worried about damage to the reputation of the company and lost sales, which, to be fair, shouldn't really be impacted by this because one driver driving badly should not, in my view, harm the reputation of a company. If many of them were doing that, then collectively it would probably cause harm to the reputation of the company. But with just one as a one-off, and many people might not think that this is such a bad overtake anyway, not to say that it isn't. I mean, some people think it is, some people think it isn't. That's for you to decide yourself, of course, and you can debate that in the comment section. But then we come to the law, as I mentioned, on unjustified threats. You see, the legal drafters that put this piece of legislation together came up with this notion that if someone had a trademark, they then might try to weaponize that trademark by going after all sorts of companies that just happen to include some reference to that trademark in some form or another, but not potentially in ways that's restricted by this act, such as the exclusive right to market goods and services using that trademark. So, for example, in this case, by way of example, in my view, this chap on a bike is not marketing goods or services by the use of this trademark, therefore it's not trademark infringement. Section 21 covers the unjustified threats of infringement proceedings. It says a communication contains a threat of infringement proceedings if a reasonable person in the position of a recipient would understand from the communication that the registered trademark exists, the email confirmed that, and a person intends to bring proceedings, whether in the court in the United Kingdom or elsewhere, against another person for infringement of the registered trademark by an act done in the UK or an act done which, if done, would be done in the UK. So that's the definition of the threat of infringement proceedings, which is quite clearly set out in this email in a number of places, not least of which the final one here. Non-compliance will lead us, not we may consider, which might still amount to a threat, but non-compliance, i.e. if you don't do what we ask, we will seek legal redress and claim any related expenses, including lost sales. So if you don't do this, we will sue you, is how any reasonable person would probably understand that message. And then we go back to the Trademarks Act, which defines an actionable threat. In other words, you receive a threat and you have a cause of action based on that threat. It says, subject to subsections 2 to 6, a threat of infringement proceedings made by a person is actionable by any person aggrieved by the threat. But then subsections 2 to 6 are if they have done such a thing, such as apply the trademark to goods and services, or they're accused of doing that, or if they would have done that, it would amount to infringement, and so on. But in the email, there was no specific threat of you have applied this trademark to goods or services. In my view, they are simply describing how it's been referenced in the video by being shown on the van, which is not his doing. It's on the van in the video. And the title and the description are reference to that trademark, but describing what has happened. And nowhere in the email does it say, here's one product that you've applied our trademark to, or here's a service that you're offering that you've applied our trademark to. It simply references the trademark as being within the video content, within the title, within the description, potentially turning up in meta descriptions and so on, and search results. But this happens all the time. And there are some very narrow cases that might well amount to trademark infringement, which is why you should always seek formal legal advice, and why this video is just guidance and just my general views. I have to say that because if you were to fully interpret this and take action on it without taking legal advice, it would be remiss of me to tell you that you cannot rely on this video as legal advice. But that's how I see this. In the grand scheme of things, I feel that this company is aggrieved that one of their drivers has been filmed, placed on YouTube, and potentially causing harm to their reputation. For what it's worth, I think that is just one driver, and it should not damage the reputation of the company, albeit the company might want to speak to that driver, and hopefully they will improve their driving. But as I say, some of you might not feel that that was bad driving anyway. I do know that many of you will think that it is bad driving and that it was far too close to the cyclist, particularly those of you that do cycle. But equally, some of you that cycle might think that it's perfectly fine. So there are lots of different views on this, but all of which are far removed from the threats of trademark infringement. However, it doesn't quite end there, because now we come back to the law on what someone can do if there has been an unjustified threat. These are what we call remedies. Now, if someone is so aggrieved by an unjustified threat, then proceedings in respect of an actionable threat, which is the one we've just described, may be brought against the person who made the threat for, firstly, a declaration that the threat was unjustified, which in other words is this chap on a bike could potentially go to court and ask the court for a declaration that the trademark's threat was unjustified and claim the costs for doing so. And just very briefly, as I'm editing this, I've realized I haven't really talked about the costs which would be involved in this. So if anyone was to, let's say, bring an action for an injunction to prevent and restrict anyone else from continuing to make such threats, I would anticipate the legal costs of doing so to be at the very least, even the first stages, £4,000-5,000 for even the initial interim injunction, and then going back for the full claim of doing so could be at least the same again or double depending on which lawyer you instruct. So we're talking about many thousands of pounds for bringing the proceedings for the injunction to restrict someone else from making those threats against you that are unjustified. All of which, of course, they will be ordered to pay if you are successful in your application for an injunction to restrict them from making such threats in the future. So we're talking thousands of pounds. I just thought I'd throw that in there while I'm editing. Secondly, an injunction to prevent any further threats. Let's say he was losing sleep over this threat and the constant fear of litigation pending and looming over him for a potential claim of trademark infringement. He could himself, if he believed that this was an unjustified threat, could seek an injunction of the court to prevent the continuance of this threat. And finally, damages in respect of any loss sustained by the aggrieved person by reason of the threat. And that's fairly broad. So, for example, if he were to seek legal advice and the legal advice were along the lines of what I've said in this video and then go to court and etc., all of those would be damages considered loss sustained by an aggrieved person by reason of an unjustified threat. So I hope that was useful and interesting to you. Do be careful going around if you have a trademark, threatening others with it and trying to weaponize it. It can get you, the maker of an unjustified threat, into heaps of trouble. If you found that vaguely interesting, to adopt the comments of my learned friend, Mr. Alan Robertshaw, who you'll find linked in the description below, please do like the video and subscribe. Around 60% of you don't. I'll really appreciate it if you do, because I do put a lot of effort into these videos. And as always, I thank you heartily for watching, and Happy New Year.